Hi guys, I am Ayushi, your mentor for law entrance exams, and welcome to Law Digest. Now, if you are a regular viewer of this channel, you must be aware that we have some popular series called revision series. We have it for Constitution, Tort, Contract, IPC. Now, there are few students who are facing a lot of problem with respect to family law, and they say that there are no questions that are available for family law and they would like to practice those questions. So in this series, we'll try to cover the basics of family law through our usual pattern of discussing 10 questions each per video, and through that we will try to discuss the basics of family law. Apart from this, obviously questions are not enough. Conceptual clarity is very important, as I always say. So just in case you are looking for some material for family law, you can check our website www.lawdigest.in, where we have certain courses available, and there's a module that's available for family law as well. Now, starting with question number 1. Now, this question says the Hindu Marriage Act. So, you should all know that family law, when we speak of family law, we are studying Hindu and Muslim law both. Now, for Hindu law, the Hindu Marriage Act deals with all the procedures with respect to marriage, the ceremonies, how Hindu marriage is contracted, how can divorce take place. All the essential points that you need to know with respect to Hindu Marriage Act is covered therein. Now, the first question says the Hindu Marriage Act does not apply to. Now, do not forget the question says not. So, just don't get carried away with the question that it is pretty easy. Keep in mind that the question says not. Now, the Hindu Marriage Act does not apply to Muslim, Christian, Parsi and Jew. This is in fact the correct answer to this question. The Hindu Marriage Act does not apply to people from these religions because they are excluded from the purview of the definition of Hindu. What is included then in the definition of Hindu? This we can cover through the next question, which says the Hindu Marriage Act applies to Hindu, Buddhist, Sikh or all of the above. Now, someone who has not studied Hindu law as such or the Hindu Marriage Act as such, they might, probably go and tick option A, that is Hindu. But when we speak of Hindu Marriage Act, people who are from Hindu religion, Buddhism and Sikhism and also Jainism, all these people are considered to be as Hindu. Therefore, the answer to this question will be D, that is all of the above. Moving on to the next question. Which of the following is not a Hindu? Now, apart from, जैसा कि अभी हमने देखा कि religions क्या है, we saw division as per the religions. Here we are going to see further how Hindu Marriage Act broadly categorizes Hindu further. Now, which of the following is not a Hindu is the question here. Both of whose parents are Jains. Now, we studied that a Hindu will mean that the person belongs to Hinduism, Jainism, Sikhism, Buddhism. So, Jainism is already included, and a person जिसके दोनों parents Hindu हैं, वो इंसान जो है वो Hindu होगा. So, which of the following is not a Hindu? This criteria is not met. This person is a Hindu, eliminated. Next, one of whose parents is a Hindu and who is brought up as a member of the tribe. So, any person जिसका एक parent Hindu है and he has been raised as a Hindu, one of the parent is Hindu and the child has been raised as a Hindu as per the Hindu traditions, then that person is also a Hindu as per the Hindu Marriage Act. Then a convert to Sikh. Now, we already studied in the second question that a person who belongs to Sikhism is a Hindu. So, a convert to Sikh is also a Hindu. So, these three options have been eliminated. We are left with the last one, that is converts from Hindu to Muslim faith. Now, obviously, someone who is a Muslim is excluded from the purview of, from the definition of Hindu. Question number 1, we are reminded of Muslims, Christian, Jews, everybody is excluded. So, a person who has converted from Hinduism to Islamic religion, that person is not a Hindu as per the Hindu Marriage Act. Correct answer is option D. Moving on to the next one. Which of the following does not fall under the degrees of prohibited relationship? Now, Hindu Marriage Act में सपिंडर relationship, prohibited relationship दोनों defined है. Now, it has been asked that इनमें से कौन सी category वो है? Which of the following does not fall within the prohibited relationship degrees? So, prohibited relationship degrees में one is a lineal ascendant of the other. That means that if there is a son and there is a mother, so mother is a lineal ascendant of the son, so these both people cannot get married. they fall under the degree of prohibited relationship as per the Hindu Marriage Act. One was the wife or husband of a lineal ascendant or descendant of the other, which essentially means that, for example, now the mother is the wife of, it says wife or husband of, the mother is the wife of the lineal ascendant of the son. So son का lineal ascendant जो है वो father है, and उस father की जो wife है वो इस son की mother है, therefore they cannot get married. Then the next is, one was the wife of the brother. So if there are two sons and there is a wife of the second son, this S1 cannot get married to the wife of the second son. So all these relations fall within the degree of prohibited relationship. The next option, the last option that we are left with, children of family friends. So children of family friends, they can get married together. These are not prohibited degree of relationships. So option D is the correct answer here. This could have been done with logic as well. This is too complicated. And children of family friends, you can relate this to real life examples as well. Children of family friends do get married. Very often it happens. So this question could have been dealt with normal knowledge as well. Now, which of the following condition is not necessary for Hindu marriage? Now, for a Hindu marriage to take place, there are certain essentials that are there. तो उस essentials में से some essentials जो हैं वो यहाँ पर given हैं. Let us look at those. We have to figure out कि which of the following is not necessary. कौन सा ऐसा essential है जो meet करना ज़रूरी नहीं है अगर Hindu marriage contract करनी है. So, no spouse living. Obviously, if a person wants to get married, he should not have any spouse living, because in that case, it will be bigamy. Bigamy is punishable under our criminal law, IPC 494. Bigamy is punishable. Then next is not suffering from any insanity or mental disorder at the time of marriage. So, it is very important that if two people are entering into marriage, any of the partners should not be suffering from any insanity or mental disorder. So this is one necessity that is there for a Hindu marriage to take place. Then groom shall attain the age of 21 years and the bride attains the age of 18 years. So the minimum criteria for age has been defined. Child marriage, as you know, is prohibited in India. So these conditions are also necessary. We are left with the last one, that is consent may or may not be given by coercion or threat. So this option is the correct option. Why? Because it says may or may not. Now if you look at the Hindu Marriage Act, it says that consent shall be free. It should not have been obtained under force or threat. So it says it shall not be. Shall means the condition is mandatory. May means the condition is discretionary. सो लॉ ये कहता है कि कंसेंट ऑब्टेन किया जाना चाहिए विदाउट एनी फोर्स और थ्रेट. कोई थ्रेट और फोर्स बिना यूज करे फ्री कंसेंट होना ही होना चाहिए. सो ये जो कंडीशन है दिस सेज मे और मे नॉट, कि हो सकता है और हो भी नहीं सकता है, बट देन दिस कंडीशन इज नॉट देयर. तो देयरफॉर डी इज द करेक्ट आंसर टू दिस क्वेश्चन. Moving on to the next one, restitution of conjugal rights can be demanded by whom? So sometimes what happens is that either the husband leaves away the house or the wife leaves the house. Then in that case, the other partner who's remaining, he can seek the remedy from the court that he wants restitution of his conjugal rights because a marriage took place and the person needs to come back. So restitution of conjugal rights can be demanded by both husband and wife. Therefore option C is the correct answer. Then moving on to the next one, which of the following is a void marriage? तो void marriage क्या होती है? So Hindu Marriage Act में कुछ marriages क्लियरली आइडेंटिफाइड हैं कि ये मैरिजेस जो हैं ये वॉइड मानी जाएंगी, दे वोंट बी कंसिडर्ड एज वैलिड मैरिजेस. Now let us look at the options that are there. If a spouse is living and contracts another marriage, as we saw in the previous question, bigamy is punishable. So if there is a spouse living and the person contracts another marriage, then such a marriage is a void marriage. Then the next is the marriage is within prohibited degree. Prohibited degree clause we already discussed in the questions before. Now prohibited degree में अगर कोई marriage fall कर रही है तो वो void marriage मानी जाएगी. Then parties are sapinda of each other. Sapinda meaning sapinda, same pind. So parties are from the same pind. How is that supposed to be seen? Sapinda के लिए there is a criteria that's given under your Hindu Marriage Act. There's a whole formula that is given. You can check it online or in the material, whatever you are referring to. So all of the above is the correct answer here, because bigamy is not allowed, then any marriage between the people who are from prohibited degree of relationship is not allowed, and sapinda relationship marriage is also not allowed. Therefore option D जो है वो इसका correct answer है. Then moving on to the next one. The next question says, which of the following is not a voidable marriage? We discussed void marriage में क्या options आते हैं. There are other options as well apart from the ones that we discussed previously. Now, which of the following is not a voidable marriage? Non-consummation owing to impotency. This marriage is a voidable marriage if no consummation of the relationship takes place because the partner is impotent, then such a marriage is voidable. Then person is suffering from any insanity or mental disorder at the time of marriage. ये एक essential condition थी when we discussed previous questions, जहाँ पे हमने बात करी थी कि essential conditions क्या ज़रूरी हैं हिंदू marriage के लिए. There we had discussed that sanity is one of the essential conditions that need to be there. अगर insanity है partner की, then it is a voidable marriage at the option of the other, obviously, that the person is willing to accept the other person or not. Then consent to the marriage obtained by force or by fraud. If the consent to the marriage has been obtained by force or fraud, then it will be considered to be a voidable marriage. Why? Voidable meaning that you are giving the option to the other party to decide whether they want to continue or not. So the other party has the option to choose. So if the consent has been obtained by fraud, but later the party changes his or her mind that he wants to continue with the relationship, then it is a voidable marriage at the option of that party. So none of the above is the correct answer here because all these options are voidable marriages. Then moving on to the next one. Which of the following is a ground for divorce? So there are a lot of grounds given under family law for divorce under the Hindu Marriage Act for divorce, and adultery, cruelty, desertion for a continuous period of 2 years. All these are grounds of divorce. So option D is the correct answer here. Desertion means that leaving your partner without any cause is desertion. So all these options they form the ground for divorce. I'd like to remind you that सिर्फ questions के basis पे मत जाना. There are further things as well. Now, if you will see grounds of divorce, so I cannot list out all the grounds that are there. There are very many grounds. So you need to simultaneously, you need to keep reading from your end as well for your conceptual clarity. अपनी conceptual clarity के लिए साथ साथ पढ़ते रहिए. सिर्फ questions पे rely मत कीजिए. Then divorce by mutual consent is provided under which section? So this is the final question. Now section 13 speaks of divorce, section 13A speaks of your judicial separation, which is an alternate remedy to divorce, and then section 13B is the one that speaks of divorce by mutual consent, where both the parties give their consent that they want to separate. So with this we come to the end of this video. I hope that you could gain some perspective from this video, that how you need to cover family law, what are the questions that might be asked, what are the basic questions that you need to know. With this I end this video. In case you have any doubts or queries, you can mention the same in the comment box below. And if you like the video, do let me know your feedback as to this video and whether you would want me to continue with these series. Then also you can let me know, and also subscribe to this channel for more such videos.